from last week. Give me two core competencies of a company secretary.
Good oral and written communication skills.
Mm-hmm.
He should have, and the secretary should have legal ability.
So they should have some
Leadership,
knowledge of company law.
Yes.
Okay.
Um,
What about their duties? What kind of what they have to do as a company secretary?
I know they draft the meeting agendas, minutes, and stuff like that.
Mm-hmm. Anything else?
Work as an advisor to the executives.
Mm-hmm. So their role is what? What they act as? They do what kind of role they play?
Easy.
They like
administrative role, right?
Right,
Smart
administrative role, right. And if they fail in their duty, what usually could happen with the company? What kind of risk they may face?
Oh, the fine, the $25,000 fine, right?
So what kind of risk? No, that's duty, that's confidentiality when we break
Oh,
it.
oh.
What kind of risk we incur? Because the company secretary is supposed to do some things.
Reputational risk, financial risk. That, what do you mean?
What about the regulatory risk? Because they have some things to file and communicate to their regulatory agency.
Right.
Remember that?
Right.
And if they don't follow through with the proper procedures, what we'll have in a meeting. Just one of the legal considerations we're talking about now.
You can ask your question again, Mrs. Dawson.
Okay, so I am a company secretary. Y'all having meetings. I'm supposed to ensure you follow the correct procedures, eh?
Oh, yeah.
Remember that? Or we may have some procedural improprieties. And then the validity of the meeting is now compromised as well, eh?
Yes.
And so if I didn't follow the proper procedures, you may have passed a minute to enter into a contractual relationship, but the wrong people were there, or we didn't have the requisite amount of people in attendance. So now the contract could be avoided, eh?
That's true.
You see, so all of these things will factor into if you were supposed to follow certain procedures and you didn't. Now it affects the company as a whole because the company is a legal person and certain things are required in order for the company to affect anything. And had you say, so for instance, when they sign, they're supposed to affix what?
Seal?
It was to
The
fix the company
seal,
seal, yeah.
right? So suppose the seal isn't on the document. I
And
could,
technically invalid.
right, so now I could ask, they'll have to ask for it to be what? They'll have to go behind, so they'll ask it to be retroactively done, but on the face of it, it's not proper, right?
Yeah.
It wasn't sufficient for it to effectively pass whatever it did or to sign whatever it did if the seal wasn't there. So if you bring a document to me and you say, oh, well, the director's already signed this, so I'm operating off this what I could say in the bank. No, I can't accept that because what happened? You don't have the what?
The seal.
Right, so when you open in these accounts at the bank will consider it not complete if you don't have the fee, the seal affixed, because they usually ask you for the seals as well, eh?
Yeah.
So they may ask you for a resolution with the company seal affixed as well. What about what the share register, what consists in the share register? What is in your share register of the company?
I guess the people who have part ownership in the company.
So the shareholders, eh?
Yeah, the shareholders.
So we'll have the shareholders, remember I said we'll have their name. What else we'll have in there?
The percentage.
The amount of shares they
The amount of
hold,
shares they hold.
their whatever share certificate number,
Mhm.
how the shares and number, and the date when they acquired the shares, eh? Likewise, if we transferred the shares or the shares were canceled, we'll show the date when they were canceled. What a proxy, would we have, what is a proxy?
So the proxy is someone that acts on your behalf.
Right, so somebody acting in proxy, so I'm absent, so I send in a proxy, which is a form where I authorize whoever to stand in the gap for me at the meeting, eh? And they could vote on my behalf if I have voting rights. Okay, so we know the role of the company secretary and corporate governance, right? How important is a role?
Very.
How important is a role in corporate governance?
It's very important
Because,
she is responsible for a lot of the administrative work for the company. She have to, when it comes to like the regulatory, meeting the company regulatory requirements
right,
and even helping with shares and distributing the dividends and all that stuff, I guess, and keeping
right,
company minutes. Like, does she keep the company minutes?
yes,
Okay, yeah.
and she's a what they call a,
Executive.
the, right, de facto what? She's the
Legal and compliance officer.
right, she have a big role. She's a legal and a compliance officer. She in a de facto role is that. Okay. Let me make sure we cover that one sufficiently. So that may be something important for you to make sure you outline. That company secretary, make sure you know about her. A role, a responsibility, a duty, and core competencies. That's important for you to know, okay?
Okay.
Make sure you have that area covered. All right, let's move on to Unit 10. Okay, this is a pretty straightforward unit, and it's an important unit as well for you to pay special attention to, okay? Okay, after completing this unit, we should be able to develop practical knowledge regarding liquidations, distinguish the different types of liquidations, gain an understanding of the liquidation process, apply your knowledge of liquidations to practical liquidation process and issues, and develop an awareness of the practicalities of liquidation. Okay, we'll start with Mr. Ferguson today.
Okay. Definition of liquidation. So liquidation is the process by which a company is dissolved and the assets and property of the company are redistributed to creditors and shareholders in order of priority. Once a company is dissolved, it ceases to exist. Liquidation may also be referred to as winding up or dissolution, although dissolution is the last stage of liquidation.
Okay, so liquidation is like the death of the company, eh? So this is their death certificate when they get the certificate of dissolution.
Okay.
All right, so we know how the company begins. How does the company begin with a what?
Articles and numbers, eh?
Right, and what is their birth certificate? Would we call that?
Your certificate of incorporation? No?
Right, right. So now we'll have a certificate of dissolution. Go ahead.
It should be noted that the winding up process is not exclusively directed towards realizing and distributing the net proceeds to creditors, and if anything is left, distributing to members of a company according to their respective priorities regarding their shareholding. Liquidation also enables a thorough examination of the conduct of the company's management to be undertaken.
Okay.
Two types of liquidation. Generally, members and/or creditors may wind up a company if it is solvent and appoint the liquidator.
So if
If
it's
it,
solvent, what is it?
um,
It's still a going concern, eh? It still can operate. It's still not in the red, more or less.
okay.
So if the company's still solvent, they can appoint liquidators. Go ahead.
Um, if a company is insolvent, the creditors may then apply to the court to have the company involuntarily wound up and may have some input in the appointment of a liquidator to act on their behalf with the court's direction and assistance.
So when it's insolvent, the creditors want to recover their money, eh? So they'll go to the court to have the company put into involuntary winding up procedure. So if I'm a creditor of a big business, say for instance, a bank that is now insolvent, I as a creditor want to make sure to secure my position. You owe me over $4 million. You probably have 5 million left in the bank. I want to try to see if I can get something back from it. So let me try to get to the courts before the rest of the creditors do. You see? Go ahead.
So solvent would be voluntary then when the company itself or some, I guess, public
Right, so you're
issues.
still in a position that you can now see if I'm insolvent, then I can't decide if I'm going to go into, I'm not, or I am going into liquidation. If I am insolvent, however, the creditor will say, I want this company liquidated. See, I may be insolvent. I can't pay my debts. And so the creditors already demanded payment from me. I am still unable to meet my payments. So this like you putting the company into bankruptcy,
Okay.
more or less. So you'll put an individual into bankruptcy. Now you put in the company, you saying, you know what? Wipe this company off the face and give me what's left. Let me try to recover something from it. So you owe me money, but you are unable or you refuse to pay me. I just go ahead and say, well, this company is insolvent. And you may have a lot of assets and you may have chosen not to pay me. But now it's for you to show that you can pay me or else you'll be liquidated. So as a creditor of a company, people can put you into bankruptcy, but that's highly unlikely in the Bahamas. That's a last step effort, eh? But in the Bahamas, they actually can put the companies into liquidation. So if you owe me money and you've refused or you're unable to pay me, you may be still trying to salvage your company and say, well, like say for instance, in this COVID time, a lot of businesses may not be able to meet their obligations. some creditors may take the hard line and say, I'm gonna have to put you into liquidation because I can't wait for you to lose any more money. Let me stop, let me freeze time where it's at, and let me try to recover whatever is left. So you may have enough fixed assets that I can get my money out, or you may have some money in the bank, but if you continue to go on, where you have employees who you have to find money for, you have light bill, you have government agencies you have to pay, what you're doing is digging the hole a little deeper, and I may never recover my money. So I may not have enough confidence to allow you to continue with the hope that you may recover when the economy opens back up. I may say, you know what, forget this right now. I just want to get my money out. So a lot of businesses right now may be in that position who are incorporated companies, especially where it may be banks or financial and corporate services providers who operate offshore. And they may, well, it's banks more than anybody. It wouldn't be the financial and corporate services company. But banks may be out there and they may be exposed, highly exposed, and lose a lot of business, so they can't continue to operate. Or a company may be exposed and can't operate, and they can now, their creditors may put them into involuntary winding up procedures. When it's like that, they have no control now. They don't have any say in who is appointed as the liquidator. The court, along with the creditor, gets to say, well, I'd like to appoint this liquidator, and it will be under the supervision of the court, of course. So the court wouldn't just allow them to be willy-nilly and do whatever they want to do. It will have to be guided through the court's process. Go ahead.
The objective of
Excuse me,
the
sorry, good morning.
Go ahead, man.
Morning, I have a
Mhm.
question. I just joined. I
Okay.
assume we're under two types of liquidation, involuntary liquidation. That's where we are.
Right, we now on, no, we just did the summary. Now we're going on to the objective of the liquidator.
Oh, okay. I have a question about what you were saying.
Okay, go ahead.
You said that the creditors can put the company into liquidation.
Yeah, involuntary.
Involuntary.
Right.
Is this, that's they have to get does the court grant them permission to put the company into?
Right, they have to, that's the only way they'll be able to do it. They have to approach the court.
So the court can say no.
Yes, if the company can show that they'll be able to meet their obligations.
Okay, so what is the recourse for the creditor? They'd have to probably do a lawsuit then.
So if you can meet your obligations, you have to be able to pay it. If you're not able to pay
I know, but I mean
no.
the creditors could now go and, since they have evidence that the company can pay or whoever can pay, they can now take out a lawsuit and just sue.
Right, so what it'll be is, if you are, see, if I've already petitioned the court for you to pay me, and you've proven that you can pay me, then
okay.
you must be able to pay me, or the process will have to continue.
Okay, so the court will make the ruling at that point to pay the creditor.
Right, so if you now say, well, first of all, you have to prove, well, you know, as much as I owe this creditor, I have this, and this to put in, but the court will say this creditor's already approached you, you've not negotiated, or you've not paid them. Prove to us why we shouldn't put you into liquidation. You see, so
Okay.
you must be able to meet your debts, and if your creditor is already, the maturity date is already passed, when you were supposed to pay, or the creditor doesn't have enough confidence that you would be able to pay in the future if they allow you to continue, then you have to prove otherwise to the court. So it's now up to the court to decide the way forward.
Okay.
Mm-hmm.
All right.
Okay.
Sorry about that.
No problem. You have to ask questions. Okay, go ahead.
So, Ms. Dorset,
Mm-hmm.
when Bahama went that winding up thing,
Right.
and they went, I think Delaware or something like that.
New York.
Oh, it's New York. Okay.
Mm-hmm.
So when he did that,
Mm-hmm.
he was basically trying to say he had more money.
He wanted to go into bankruptcy. So if you go into bankruptcy, you will get to keep, and see what he's doing is he's trying to keep, some people wouldn't get paid like that.
Oh.
You see, with bankruptcy, you may get to start over. because now they'll stop and say, well, these people don't have to, you can't pay them because you've claimed bankruptcy. So you jump the gun now. You see, he had to go outside of the Bahamas because it's not like that here. You don't get to just go into bankruptcy and you able to avoid these creditors. That's a hard threshold to pass. And somebody may want to put you into bankruptcy and get whatever's left, but they may not want to put you in bankruptcy and they may be last on the line. In the company situation, we'd want to put you into liquidation and try to recover whatever we could. So when it goes into liquidation, now remember the company's going to pay for all of this. The court costs, everything. It's nothing to do with the creditor. The creditor won't have to pay it if it's, see, because it's a procedure they have to follow. They have to make a demand on the registered office first. And then you have time to answer that. If you've not answered, then it's a process before you get to the court stores. So you don't just go to court. You have to go through the procedures. Okay.
The objective of the liquidator is to ensure that the assets of the company are secured, received, realized, and distributed to the company's creditors initially. And if there is a surplus, to distribute the assets to those members or stakeholders who may be entitled.
So that's the first thing. The objective of the liquidator is to ensure all of the assets of the company are first secured. So I don't know, you saw Cavalier. Here is a company that's closed down. And what they've done is secured the premises first, because even the building may have to be sold to pay their debts. So you have to receive all of the outstanding receivables, realize what you have before you, and then you'll be able to distribute to the creditors initially. And if there's any surplus, the shareholders will get what they should get. Okay, go ahead.
One, voluntary liquidation process where the members of a company resolve to voluntarily wind up the affairs of the company and dissolve.
So when they voluntarily do it, what would we say the company is?
Wind up.
Right, and it still may be solvent, eh?
Yeah, it's not really solvent.
Go ahead.
Involuntary liquidation process where the court makes a winding up order on the petition of a creditor or an aggrieved minority shareholder, where the winding up of a company is commenced by a court order. The liquidator exercises its power under the direction of the court and is required to obtain the consent and/or authorization of the court before entering into any transaction.
Okay, we have an aggrieved minority shareholder who may also petition the court for the company to be wound up. If I am a part of a company and I say, well, I am a minority, so the majority makes all the decisions. So they decide if the company's going to enter into this to my detriment, because I may be looking to receive some dividends, or I was actually hoping that the company would have settled with this investment we did. They say, oh no, they decided as the majority shareholders, we're going to go into another investment. And I thought I would be able to get some of my money out, or I would have been able to come out. So if I am now being bullied more or less by the majority, I can petition the court. Of course, I have to make application and say why I'm approaching the court. And the company has to show sufficiently why it shouldn't be, again, involuntarily liquidated, because otherwise they may say, well, we'll pay out the minority shareholder. Since it's like that, we'll pay them out and we don't have to go into liquidation. But if they're not able to pay them out, they may have to be again liquidated. So it's another involuntary exercise.
Is there a difference between the terminology dissolve and liquidate?
Now, liquidation usually it happens where it's done through the courts. Dissolution is usually done where the company takes its own measures to be dissolved. So at the end of the day, the company is dissolved. It's
Okay.
no more because you get not a certificate of liquidation, but a certificate of dissolution, or it's liquidated through the court and the name is taken off the register.
So if
There's
it's
a-
court, it goes to the court would issue the
It
registry
will
will
give an
issue a
order.
liquidation.
No,
Oh.
no, it's an order. It's no liquidation certificate. It's a certificate of dissolution.
Right, I get that, but that you said that's when the company decides to dissolve itself. But
I
if
know
the
what I'm saying is it's at the end of the day, it will
Right.
be all of the assets are being dissolved. The court will issue an order. So the
Okay.
company will be removed off of the register based on the
Right.
court's order.
Okay. So
Whereas,
the court would issue, go ahead, I'm sorry.
no, go ahead. You tell
The
me.
court would issue an order to the
Mhm.
registrar to say remove this off the books, and then they would issue a certificate of dissolution.
So what happens is the court has appointed liquidators, eh?
Right.
So the liquidators have to do the necessary to get the company now off the register of the company's register. So you still get a certificate of dissolution in the end.
Okay.
So remember, it's not dissolution or not dissolution. It's either voluntary or
Or
involuntary.
involuntary.
Right. And at the end of the day, what you get is
The dissolution document.
the certificate of dissolution.
Okay.
Because there's only two types of voluntary.
I just see people seem to use it and use the terminology interchangeably, and it could be confusing sometimes.
Right. So at the end of the day, you get a certificate of dissolution.
Okay.
And
All right.
you resolve to dissolve the company.
Okay.
Whereas the company has been dissolved in accordance with a court order or as a result of whatever the court's orders are.
So liquidation is actually getting rid of the assets.
Right. So what liquidation is? The process by which a company is dissolved, and the assets and the assets and property of the company are redistributed to creditors and shareholders in order of priority.
Okay.
You see?
Mhm.
Because see what happened is dissolution happens at the end.
Right.
Liquidation is the process you get to dissolution.
Okay.
So the liquidation process is what is really how you get to it. So either you do it involuntarily or you do it voluntarily. So at the end of the day, everything is dissolved, but it's how you get there. Because you need a certificate of
Dissolution.
which is your death certificate if you were a natural person.
Yes.
Okay. Sorry. Okay, go ahead.
Two types of voluntary liquidation. One, members' voluntary liquidation process where the directors and shareholders of a company decide to put it into liquidation and the company is solvent. Example, there are enough assets to pay all of the company's debts. And then the second is creditors' voluntary liquidation process where the directors or shareholders of a company decide to put it into liquidation and the company is insolvent. There is not enough assets to pay all of the company's debts. Voluntary
So we have the two types where the members put it into liquidation or the creditors can voluntarily liquidate. So we know the two types now, eh?
Yeah.
You all have a sufficient understanding of what happened in here, right?
Yes.
So when I put it into liquidation, I'm able to pay off everything I owe.
Okay.
You see? So I may say, you know, something, we going down, you know what we better do? Let's pay off Commonwealth Bank, let's pay off Royal Bank, let's pay off whoever we owe there, those little people. And whatever left, that's what we'll break away with. As shareholders, we'll say, we'll call it a loss or a gain, whatever it is, but let's get out of this now before it gets worse.
So
So why
so
they say
the
creditors in this? Why they call it creditors
right.
voluntary? Because the
That's
directors of that company
involuntary.
decided to but it's say the process where the directors or shareholders of the company
Right?
decide to put into liquidation. But why they say creditors voluntary liquidation?
So
Right.
because there's not enough assets to pay off all of the company's debts. So they can pay some off, but they can't pay all. So it is a creditor's voluntary liquidation in that instance, where remember the first time the members do it. This is a members voluntary liquidation. They decided, you know, something, we owe money, but we have sufficient to pay off our debts. It's for the creditors when we don't have enough money and we still gonna put the company into liquidation. There's not enough to pay off all, but we still gonna do it to try to pay some. So they'll negotiate with their people on how
Okay.
they'll pay everybody. So they're
That is
still willing to do it. It's still a voluntary process. So when it's done like this, it saves some money, because you didn't have to go to the courts.
the creditors didn't have to take you to the court.
Right, so the company, and so you will save a lot of money, because when you go through the process of the court appointing the liquidator, all these things, you incur a lot of fees, and then this liquidator may be a liquidator who may charge an exorbitant amount because they're court or appointed liquidator, whereas if you could negotiate, you may use your own people to be the liquidator. So sometimes if you're working in a company section, the directors may be the liquidators. You see, so they'll say the liquidators are being appointed and they're the same people who are the directors. So like that, you didn't have to appoint anybody outside. You didn't have to pay liquidator fees. You didn't have to pay court fees, attorney fees. You've avoided a lot of fees. And so you may be able to pay some of the company's debt without incurring an additional liability.
So the difference between this creditor's voluntary liquidation, this is not orchestrated by the creditors.
No.
It's only for the benefit of the creditors.
Right, but it's not,
Okay.
and it's done by whom?
The directors and the shareholders,
Right, so it's voluntary
Okay.
when it's still done
Okay.
within the company's authorization and their scope.
Okay.
Go ahead.
A voluntary liquidation of an IBC. Under Section 2 of the IBC Winding Up Act, a company incorporated under the IBC Act may be wound up under any circumstances in which a company incorporated under the Companies Act may be wound up. The Companies Winding Up Amendment Act 2011, the Companies Winding Up Act, and the International Business Companies Winding Up Amendment Act 2011, the IBC Winding Up Act, govern the voluntary liquidation of an IBC in the Bahamas. Under the Companies Winding Up Act, an IBC may be A, compulsory wound up by the court, and B, voluntarily wound up by resolution of its members pursuant to the company's articles of association or upon its expiration. Example, limited duration company, or under the supervision of the court.
Okay, so on the expiration, in this instance, LDC, what they call a limited duration company, it's a company that's only incorporated for a set time. So you may only incorporate a company for a purpose. So you may say, I only need this company for 10 years. So that's the life of the company. You'd say this company is incorporated for a period of 10 years. So that's an LDC and it's only for that purpose. Once that time is up, then it's now going to be dissolved.
Okay, question. These different acts. I trying to, because some of these in brackets and then some.
So what they do is they short name it, so you don't have to say the whole name
Oh,
again.
okay.
You see, so it's a short name for it. When now, so that's also referred to as, so it's also known as, that's what you'll have it as. So from this
Okay.
point forward, instead of you saying Companies Winding Up Amendment Act 2000, you'll just say Companies Winding Up Act.
Okay.
And from this point forward, you just say the IBC Winding Up Act. That's what that bracket means.
Okay.
Mhm.
All right. So under section 211 of the Companies Winding Up Act, 1992, a company may be wound up voluntarily if one, the
Okay,
period.
so now let's make sure. Now this voluntary liquidation is important, so let's pay special attention to this section, okay? All of this voluntary liquidation, okay?
Okay. One, the period, if any, fixed for duration of the company by the Articles of Association expires.
And what that is, a what?
That's the.
It's a LDC.
Right.
Whenever an event occurs, the occurrence of which the article of memorandum of association provide the company is to be wound up.
So it may be that you may put in there that on the happening, so on the realization of us paying off for a building or on the realization of all of the assets being sold or whatever, the company will be, that'll be a part of your bylaws. It'll be settled in your articles or it may be in the memo. You may say, we make provision that once this is accomplished, we no longer need the company, so it could be dissolved.
Three, a resolution requiring the company to be wound up voluntarily has been passed by a majority of not less than 3/4 of such members of the company who are entitled to vote under the provisions of the Articles of Association.
So you can't just, if you are 10 shareholders, you can't just have 3 who have decided that they gonna wind up the company. You need 75%. If it's only 3, what that is, they are what? Or the 10, they are what?
Well, the 10 is only 30%.
So that's a minority, eh?
Yeah.
So what do we say about the minority, aggrieved minority, what they'll have to do? You have to petition the court, remember?
Oh, yeah. They have to go to court for that. Yeah.
Right. Go ahead.
4, the members of the company have passed the resolution that it has wound up voluntarily because it is insolvent. Note that insolvent is defined as when a company is unable to pay its debts as they fall due or the value of the company's liabilities exceeds its assets.
So now that's a clearer picture of what it is. Insolvency.
Yeah. As under section 212 IBID, the voluntary liquidation of a company is
so they now just so you know what they mean by IBID, eh?
No, I don't know that.
So that's like did the same thing as under the company's 211. You just had under section 211. So now of the company's winding up act. So this is under section 212 of the same act. So they just have dot, like when you writing something over and over, you just put the 2 little apostrophes up top.
Okay.
Like you repeating it.
One, at the time of the passing of the resolution authorizing such winding up, or 2, on the expiry of the period of the occurrence of the event specified in the company's memorandum of association of articles of association, sorry. Notwithstanding that a supervision order is subsequently made by the court. Process of voluntary liquidation for an IBC. 1. Resolution of members or directors as required by the memorandum of articles of association that the affairs of the company should be wound up. 2. Appointment of a liquidator. 3. Approval of the proposed plan of dissolution and execution of the articles of dissolution. 4. The executed articles of dissolution are submitted to the Registrar General for registration. The date of the article of dissolution is the date of commencement of the winding up of the IBC, unless the articles of dissolution provide for another date, which shall be within 30 days of registration. And 5, the liquidator takes responsibility for winding up the company's affairs, example, paying debts, gathering assets, managing bank accounts, etc. Under the IBC Winding Up Act,
So we see the
following
process,
provisions-
right? You see the process for voluntary. We first do the resolution. The resolution includes the appointment of the liquidator, and it approves the proposed plan of the solution. So you would have a proposed plan of the solution. You would have the name, who is going to be the liquidator appointed. Your resolution will say that you all have resolved that the affairs of the company should be wound up. So the same plan of dissolution, and it will now be submitted to the Registrar General for registration. Articles of dissolution is the date on the commencement of the winding up, unless the articles provide for another date, but it should be within 30 days of registration. Then the liquidator takes on the responsibility for winding up the company's affairs within that time. Go ahead.
Under the IBC Winding Up Act, the following provisions may be permissible in a liquidation. Section 90, interest on debts. Section 91, 90, subsection 1, I don't know how to say that, but subject to section 90, subsec 5, a winding up interest is payable in accordance with this section on any debt approved in the winding up, including so much of any such debts as represents on the remainder of the debt.
So they'll be able to apply some interest on the debt, the creditor that is.
And then section 90 sub 2, or how do you say that? Any surplus remaining after the payment of the debts proved in a winding up shall, before being applied for any other purpose, be applied in paying interest on those debts in respect of the period during which they have been outstanding since the company went into liquidation. Section 93, all interest under the section ranks equally, whether or not the debt on which it is payable ranks equally. And then section 94, rate of interest payable. And then section 90, subsect 5, no interest shall be payable if the liquidation is concluded in less than 6 months of the accrued amount in less than $500. Is less than $500.
Right. So then if the liquidation can be completed within 6 months, if there's no interest to be paid. Or if the company owe you $500, you have nothing to get. All right, go ahead.
So if I owe you less than $500, you don't have to give me no money?
No interest.
Oh, no interest. Okay.
Right.
Okay.
Now we still in the process now. Remember, we still following this process.
Okay. 6, the liquidator advertises for creditors during the liquidation process. 7, notice of dissolution must be published within 30 days of the registration of the articles of dissolution. 8, the liquidator prepares a statement of account in respect of his actions and transactions in the liquidation process and forwards a copy to each member. 9, the liquidator submits a statement or notice to the Registrar General that the winding up such dissolution has been completed. And 10, the Registrar General strikes the company off the Register of Companies upon receipt of the notice and issues a certificate of dissolution certifying that the company has been dissolved. The date of the certificate is the date of the dissolution of the company. And 11, the liquidator publishes a notice that the company has been dissolved and has been struck off the registrar in the official gazette upon issuance of the certificate of dissolution.
Okay, so not after the company has been dissolved, you still have a responsibility to publish the notice that the company has been dissolved and the date it's been dissolved.
Who's the official gazette?
That's like the Guardian or the Tribune.
Which one is official? Both are?
Both.
Okay.
Section 166, Restoration of the Register of Companies. The company, a creditor, member, or liquidator, may within 5 years following the date of the striking off of the company, apply to the registrar to have the name restored to the registrar, and upon payment of the prescribed fees, $600, and all fees due under the Act, annual fees and late penalty fees for each year, the company name can be restored to the register.
So this is within the 5-year period, you can have it restored just by applying, paying the fees and all the outstanding fees, and the company would be restored to the register.
So what is this? This is when if I want the company to come back again?
Right, so the company was struck off or you liquidated it. You would say, you know something, I just realized we have a bank account in London and we didn't deal with that. So within 5 years, you may discover that you'll say, oh boy, I better get this back on the register in order for me, because you have to produce certain things to get the money out of the bank. You may have to show that the company's in good standing, it's still living. That's the only way you will be able to show that. So now you'd go back to the registrar and pay for the company. That's the only reason you'd want to restore a company, because you have found out that you had some assets out there, or you have things in it dated the company.
So they find you hiding money.
Right. So the company may have
what if you still owe creditors? What if you still owe creditors?
So you will be back on the hook, with the creditor. Now remember, the creditor was supposed to be notified by your advertisement. You see, because your advertisement would say any creditors can make your claim here within whatever time. You see? Or we may discover that we liquidated the company, but we thought it was in Johnny's name, the house, the estate, the palatial estate in Europe was in Johnny's name, but actually Dad had put it in the name of this company. And now we can't do anything with the estate. This is a house along with all of the ranches, whatever they have out there. We can't do anything with it because it was actually in the name of this company that we decided to liquidate in the Bahamas.
Was so the liquidator supposed to catch all this?
Yeah, but the liquidator only will know as much as the records provide me.
Okay.
So he's a liquidator in the Bahamas, and he didn't realize you all had assets in Saudi Arabia, in South Africa, in France, in Switzerland. The only thing you all had here was y'all owned property in Switzerland, y'all owned bank accounts in Switzerland, y'all had a estate in France, but he didn't know about the rest of the places. So now you have an oil well, they have some place where people working for you and they didn't even realize it. Because he put all these things in the company, but they had not sufficiently kept good records, eh? So now they going back to try to restore this company.
So this notice that you have to put in the Gazette,
Mm-hmm.
how would the creditors know that it's in the Gazette if they live in well, yeah, if you have a business in Switzerland and the Gazette is published here, how are they
So
supposed
now,
to know?
as a creditor, if you are crediting to a company, you should make sure that you're put on the on the register of mortgages and charges.
Yes,
You
yes,
see?
yes. Okay.
Because if
Oh,
I
that's
am
what's
not,
wrong.
right, if I'm not in the Bahamas, there's no way
Okay.
for me to find out when you're
I see.
liquidating that, because there's no notice for the world when I'm a Bahamian. I can't be saying I go advertise in France and all these places. I only advertise in the Bahamas. So
Right.
if you are a creditor and you have sense, you would say, I lend in this company money. I want you to
Right.
file my credit, my charge on your mortgage of register and charges, and provide me with a copy that it's filed with your registrar general.
Ah, okay. All
So
right.
that's what most creditors do who are in Europe, or they usually ask for that to be done.
So the registrar would honor, the registrar responsibility is to honor that or
So you
recognize the
can't,
charge.
right, so that's a part of, so just when you go to the registry, they'll say, well, basically, you can't get a certificate of good standing because you've not paid the annual fees.
Right.
So they'll say, well, this company can't be dissolved because we've not seen whether you have satisfied
Okay.
this debt, you see? So show us how this debt has been satisfied. And that's what they're supposed to be doing, because they will go through the whole company before they strike everything off. That's a part of the process. And so even when you search in the company to see the registrar, the liquidator would have to do that, do a company search, to see
Right.
that there's no mortgage of register of charges or charges to notify the creditor that this company is in liquidation. And please send us show what is outstanding to you as a creditor.
You think
Because
that
now the
actually happened?
liquidator will be on the hook, remember that, if they've
Yeah.
not done that.
Ms. Dawson, do you have an example of the complete process of documents filed and?
I will love to see. I don't think I have it on me. I will see if I can find one for you. I'll see if I can find one so you could see an example of how it looks. But I don't know that I have it this weekend.
Okay.
Okay. So within 5 years, we get it restored by just paying the fees and the restoration fees to the registrar. Go ahead.
Okay, section 166.3. If a company has been dissolved or the period of 5 years has expired, the company or a creditor, member, or liquidator may apply to the court to have the name of the company restored to the registrar.
So this one is a little more complex because now you have a lot of court fees to pay. You have to now send your notice you have to send your application as well. You have to serve it on the Attorney General's office. They have to have someone present and they can object or not object. But in any event, they ask for fees for them attending court with you to have the company restored to the register. So in this instance, you would have to, the director or whoever it is, will have to do an affidavit to say why they want the company to be restored. And this will have to be done by summons. And then the court will decide if it is to be restored after all the fees have been paid. So that's a little more complex. And then you would have to hire attorneys to help you with getting that put back onto the register, because you need an attorney to be present with you, right? Okay,
striking off IBC Act 2000, Section 165, and IBC may be struck off the company's register if it no longer satisfies the requirements of Section 14.1, 38.1, and 44 of the Act.
and what that is? What is 14.1, 38.1, and 44?
Um,
Don't know. I think we know 44, what 44 was.
So I'm sure which numbers.
Mhm.
Oh, my aunt and the family.
We just do that one before, what it is, this, Wesley, we would deal with 44, no, with the filing of the,
I'm
Directors,
looking, I'm trying to.
that's director.
so, where the IBC must keep the register of directors and officers,
Right.
what is 14.1? So you
Is
all
that the
can,
registered agent?
No, that's 38, I think.
38 is what? Registered agent.
Agent in the Bahamas. It's always
Mhm.
have a registered agent in the Bahamas.
Well, that's members then.
What member says? What it
Shareholders.
says? 14?
I'm
14,
thinking
the
about all
articles
the,
shall be subscribed by two persons in the presence of another who shall sign his name as a witness.
Mm-hmm.
And such articles shall be filed with the registrar on the same date as the filing of the memorandum.
Okay.
that's
So,
14.1?
That's what on the IBC Act. I'm in the IBC Act now. That's what it says.
so it'll be struck off as no longer satisfy these things. What 14.1 says?
No, the articles shall be subscribed to by two persons in the presence of another who shall sign his name as a witness, and such articles shall be filed with the registrar on the same date as the filing of the memorandum.
Okay.
What that means, I thought that's a part to do with incorporation.
Yeah, but sometimes some things have been overlooked. Like the other day, we were trying to get a certificate of good standing, but the company was red flag because when they submitted the memo on arts, they had not submitted the affidavit of the witnesses. So as much as it's an online process and it went through the system,
Oh,
they
oh,
recognize it after the fact. So now you can't even proceed. You can't do any more business until you get those things in order.
okay.
So you may be on the register, but not, it may be struck off eventually if you've not complied with these things. Okay,
Section 165.4, a company struck off the register remains liable for all claims, debts, liabilities, and obligations of the company, and the striking off does not affect the liabilities of any of its members, directors, officers, or agents.
so when it's struck off, you're still on the hook for whatever is out there, right? So if
Okay, that's what I was asking.
right, if the company is still on the books, more or less, because it's still on the book if we've not issued a what?
Dissolution document.
Right, if it's not if it doesn't have its death certificate, it's still liable for anything out there, all the things that affects it, the liability, everything that's still out there, all its obligation, if it owes the creditors still running interest and all that, because what we say we're gonna do, stop time, right? By voluntarily liquidating the company. Okay?
Section
Where,
1, Section 167, effect of striking off. A company which being struck off the register still incurs liabilities a creditor can bring a claim against the company and the court may appoint an official liquidator.
So you see, if you leave it there, it is now attracting it still is incurring all the liabilities of the creditor. So whatever interest he's charged and all of that, so you've not stopped it from continuing. Because we usually freeze time. That's like if the bank takes you to court, the day they take you to court is when they freeze the principal, eh? Yes?
Yeah.
So if I take you to court, that's where it ends. That's all, everything stops there. You don't get to add on anything else because you've decided that our relationship is severed, eh? When you have decided to take me on to court.
Right.
Okay,
Section 169, dissolution of company struck off. If a company is struck off under Section 165 and remains struck off continuously for a period of 5 years, the company shall be deemed dissolved. But the registrar may, if in the best interest of the Crown, apply to the court to have the company liquidated and appoint an official liquidator.
and what interest it'll be in for the Crown? What interest, why they'd want to apply a official liquidator?
I guess they may have some taxes they owe. I don't know.
And so the company may have something they could get for those taxes, eh? So they only could get this money, this company may have monies, stuff outstanding to it, and they may want to now take that into the central bank and use it for the government to use it. Because they say this company being on the register, they've incurred fees and penalties, and they actually have some assets left, so let's put it into liquidation and get our money, eh? Okay.
Involuntary liquidation.
Mhm.
The winding up and dissolution of a company incorporated under the International Business Companies Act may be wound up under the same circumstances as applicable to a company incorporated under the Companies Act. The circumstances in which a company may be wound up by the court are if A, the company has passed a resolution requiring the company to be wound up by the court. B, the company does not commence its business within a year from its incorporation or suspends its business for a whole year under the amendment to the IBC Act. C, the company is insolvent. D, the members are reduced in numbers to less than 2. E, the court is of the opinion that it is just and equitable that the company be wound up. And F, a regulator petitions for the winding up of a company which has regulatory authority and whose license or registration has been suspended or revoked. Section 190 of the Companies Winding Up Act states that an application to the court for the winding up of a company can be made by petition presented by either 1A, the company after passing a resolution requiring the company to be wound up by the court. B, any creditor or creditors, including any contingent or prospective creditor or creditors. C, any contribution or contributories, any contributory or contributories. D, a relevant regulator pursuant to regulatory laws where a company which is not duly licensed or registered to conduct a regulated function may be wound up by the relevant regulator. And then 2, where the articles expressly provide the directors to wound up the company without the sanctions of a resolution passed at a general meeting. An application for winding up shall be determined by the court within 6 months of it being made unless the court is satisfied that special circumstances justify an extension not exceeding 6 months. Upon hearing the winding up petition, the court may dismiss the petition, adjourn the hearing conditionally or unconditionally, make a provisional order, or make any order or make any other order that it thinks fit. But the court shall not refuse to make a winding up order on the ground only that the company's assets have been mortgaged or charged to an amount equal to or in excess of those assets, or that the company has no assets. The role and responsibilities of the official liquidator and procedure for winding up under the supervision of the court are set out in the Company's Winding Up Act.
Okay. So you see, it's similar to the voluntary, it's just through the court's process, eh? Hello?
Yeah.
So the court may dismiss the petition, adjourn the hearing conditionally or unconditionally, because what the court may do is adjourn it until you can show cause as to why it shouldn't be liquidated. You may say, I'll be able to pay the creditor, so they'll say, we'll adjourn this on this condition, you go ahead and pay it and then come back and then we'll see if we should continue with this process or not. Or they will make a provisional order that in the meantime you do that and then come back to us at a certain time. We'll see if we should continue with this. Okay, but you see, they wouldn't just refuse to make the winding up order on the grounds that the company's assets have been mortgaged or charged to an equal amount or in excess of those assets, or it has no assets, because notwithstanding it may have a mortgage. This is how the people may get out of it, eh? They'll say, well, we can't pay it no more, liquidate the company. All right.
So you have to do bankruptcy. The alternative to that is bankruptcy.
They don't, that's what I'm saying. Why they're not gonna let you do bankruptcy, they'll say, go ahead, liquidate the company.
Do we have bankruptcy over here?
Yeah, but it's so far reaching, it's really a difficult process to go in. It's usually done for individuals, but you would have to, most people don't go through it because you have such a high threshold to meet to put someone into bankruptcy. And it's not beneficial for the creditors, eh? Unless you have some asset they could recover outside of what it is so you may owe the bank $100,000 and you will say, well, I don't have any ways and means of paying it. So they may say you are a bankrupt, right? And try to recover by making you sell your assets.
But can I declare bankruptcy? Can I, as a person, declare bankruptcy?
No. Someone have to put you into bankruptcy.
That's that. Oh, that's that work. Okay.
Mm-hmm. Now, see, in the States, I think they allow them to declare bankruptcy. But you see over here, they don't allow you to do that. That's why you have the banks saddling you with debts well into your old age. For a $2,000 debt, you paying $10,000 almost 15 years later. Because you say, well, I only could pay $20 a month. The basic fact that you only could pay $20 a month on a $10,000 debt says that you're bankrupt, and the United States would allow you just to be put in, you could go ahead and file for bankruptcy. You come back after 7 years and you start fresh. Whereas you still 7 years in and you still ain't finished paying the creditor. So a lot of what they're doing here is, I mean, the banks already charge exorbitantly on the front end, and on the back end, they still dragging you down after they would have collected all of their money from the get-go. What they really chasing now is they call it that they were getting their interest first. They got their principal long before at the time. They're looking for their profit now. And so while some of them may have already gotten their profit, they're now able to tack on because now they have, for instance, I think like you have Gateway in this instance, say Mr. Ferguson, you work at Gateway, and Anisha.
Yes, ma'am.
You're buying debts off of other companies. And now you tacking on your own fees onto the debts that these people already paid almost 10 years ago. So I mean, you know, the system is unjust over here because we're not at the standard we should be at, and the laws don't make, they're not just for the consumer.
Not at all.
There should be no way I've been paying Scotiabank for 20 years and I owe Gateway for another 10 years on the same debt I done pay Scotia 10 times over.
I think, well, I mean, that's something we have to change the laws. The law have to step in.
Yeah, it's really unfortunate because
Yeah.
there should be no way I started a debt from I was 20 and I still 60 paying the same debt, but I only borrowed $21,000 and I
Yeah.
paid them $21,000 almost
10
20 years
times.
ago. And now every time you think you finish with Scotiabank, they sell it to someone else and these people just on the up and coming and
Well, you
they
know,
overzealous.
Scotia doesn't have the best banking practices. I don't know if anybody here worked with Scotia.
Not even best banking practices. They don't
But
keep
they could
proper
speak.
records.
They have
Yeah.
no records. They have, and the unfortunate thing is these people who buy Scotia's debt now, if these people really challenge them in a court, there's no way they could prove the debt.
Right.
Even right now, national insurance can't prove certain debts that they say people owe because they'll say you've not paid and you only have to have a couple of receipts to show otherwise. And so now the whole thing is questionable. Because if I have these 3 receipts and you don't even have them, what else you don't have? Or what else haven't been reported properly? So it shows that there's a lot of lack in the whole system. And it's unfortunate because every time you have to prove yourself by producing receipts. So I mean, what that means is they either have people who working in the organization who's stealing from the poor people, and then you carry me to court for something I've already paid you. You say, well, no, I could show you have not paid it, and some of the people really don't have their receipts because you print these receipts on a thermal paper that goes back, that's faded in a matter of months.
Right.
So I mean, I think it lends to dishonesty with all what they're doing all around. So I mean,
I find that Scotia doesn't close a lot of their accounts either properly. Like you would think you paid off your account with Scotia, and
okay,
they did not pay. The system is gonna still generate that, hey, they owed $5 at some point, and
yes,
then
and
you
then
know
it
interest are kicking
tacks
in.
on, it keep
Yeah.
tacking on, and then when you
Yeah.
look,
Right.
$5 turn into $1,000, and then
Yep.
over the years it's now up to 20,000.
Yeah.
Yep.
So it's no way a bank took someone to court for 50,000 and now they're saying some, I should say, so we're talking about 4 to 5 years later, they saying the person owed 256,000. Is that,
Yeah. Yeah.
I
It's
mean,
crazy.
dishonesty is
It
dishonesty.
is.
Yeah, and see what I'm saying is you living among these people and you facilitating and enabling that dishonesty for a foreign bank to really cripple your own people, and you wonder why this country in the state it in because of
Yeah.
what the dishonest practices that's happening with the banks. So you have to make sure that these administrative functions are carried out properly, and when these people go to court, they can't just be intimidated by the banks coming with their lawyers. It pays for some of them to come with their own lawyers because they're being bullied and they're disadvantaged by the practices that go on with the banks.
Yeah.
So all of these things, everyone must have a conscience when they even working in these organizations because you know sometimes you have overzealous people who work there and they so caught up on emotion sometimes because you know
Yeah.
sometimes you call these people they really had it with the bank, they may kick off on you but it's nothing personal, it's really directed towards the organization, and then you take a higher road to say, oh okay, you showing off today, let me send this over to the lawyer, carry the court, whereas the person just frustrated with the whole process.
Yeah.
I
It'll
agree.
be more so tears than anger.
Yeah, because you can't believe they
Yeah.
coming to you a year later and you just paid that and now you really can't prove it. And it seems as if they all know it, but really and truly they calling your bluff. They posturing before you, so you have to posture back. And if you
Yeah.
go to court plenty times, they have no ground or no legs to stand on.
Yep. And I mean, Scotia's has some good interest rates, you know, but boy, they do not have the best the best banking practices to say.
Right.
It's
So that,
ridiculous. It's
right.
ridiculous.
It's not fair. It is not fair. Now, before we go into our questions, they want to know, they want to do the exam on Thursday, they say, not Friday. But they want to do it from 2:30 till 2:45 to 5:45 or 3
What you
to
said,
6.
Miss Dorset? What you said?
You said Thursday? They
Yeah,
changed the
Thursday.
date?
They
Because
bring the date up.
they can't do it on Saturday.
Well, they can't
No,
bring
but
the
when I
date
spoke to
up.
the date, she told me Monday, November 2nd, so now they changed it to Thursday?
So no, that's why I'm asking you. She wants me to ask you if Thursday is good. So if not, then
Thursday.
you all will have to do it the Tuesday following, I guess.
You
That's
can't bring the
Thursday
date
coming?
up.
Okay, so you all are
Can't
not
bring
in
the date up.
agreement to both the data.
So Ms. Dorset,
Uh-huh.
the date she told me for Monday, November 2nd, that is off then. Because I already
No.
put in that request for that day at work. Oh,
No, she's saying if you don't be
oh,
free for Thursday coming, then it would still be that Tuesday.
Well, let me find out. Let me ask if Monday is better for you. You want to hold on a second?
yes, because I already requested and got that day approved to take the test.
Okay,
Just leave it for Tuesday. If it's already there, you wouldn't have to change the date, but it can't be an
No, it was
earlier date. That
Monday. It
give
was
it.
Monday.
No,
It was Monday still.
she has it as Thursday. That's why I'm saying to you, if she told Nishka it was Monday, let me go back to her with that, okay? I'll
I'm
call
sorry.
you.
She meant Thursday of next week or the following
No,
week.
this week, this Thursday.
Oh
Oh no.
no,
Okay.
that's
No.
short notice. No.
Okay, let me call. Hold on one second, okay?
Okay.
Look over the questions until I ask for questions, so we'll know these answers right off. Hello?
Hi.
Okay, she said Monday is fine at 2:45.
Okay.
So everybody got that?
Yes.
Say from 2:45 to when?
Make sure that's
To
fine.
5?
Make sure it's fine.
2:45 to 5:45.
Which date is this exactly?
Monday, November 2nd. I don't, SMCK, who's that? Shadell?
Yes, that's fine. That's fine with me.
Okay, good. Okay, so I'll put everybody to confirm. The only person we have to confirm with is Ms. Rahman. So now we have the majority. So Ms. Rahman is in the minority. She'll be an aggrieved minority because we'll have that date set, okay?
Yeah.
Okay, define liquidation for me, please. We will find that answer.
The process, that's page 99, paragraph 1.
And what is liquidation?
Process by which a company is dissolved and the assets and property of the company are redistributed to creditors and shareholders in order of priority.
Okay. Describe the two types of liquidation. What are they?
Voluntary
Voluntary
and
liquidation and involuntary.
And
Page 91.
voluntary, right? What voluntary deals with?
where the company,
Process.
Decide to dissolve the
Yeah.
company.
And involuntary is,
like court order.
Creditors.
right, the court is dealing with that one. The answer is on page what?
99.
99.
Okay. What are the two types of voluntary liquidation?
Creditors
Members, creditors.
and members.
It's on
Members
page 100.
voluntary and the creditors, that's on page
100.
100, okay.
100.
Number 4, describe the liquidation process for an IBC. Where we'd find that process.
One oh one.
101, and it's how much stages in the process?
It's quite a few.
From
About
1 to
11,
what? 1 to
11.
11, okay,
11.
good. Subject to section 90, subsection 5 of the International Business Companies Winding Up Act 2011, a blank is payable in accordance with this section on any debt proved in the winding up, including so much of any such debts as represents on the remainder of the debt. Where we'd find that answer?
Page 101, that's the interest. Page
Everyone got
101.
it?
Yeah, page 101. Yeah.
That's the winding up interest.
Yes.
Under section 165, subsection 4 of the IBC Act 2000, a company struck off the register remains liable for all blank, 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 and blank of the company, and the striking off does not affect the liability of any of its members, directors, officers, or agents. Where we'd find that answer?
Page 102.
And what is that?
That's the claims, the debts, the liabilities, and
Liabilities and
obligations.
obligations.
Okay. Number 7, the company, a creditor, member, or liquidator may within blank years following the date of the striking off of the company apply to the registrar to have the name restored to the register. And upon payment of the prescribed fee of blank and all fees due under the act, annual fees and late fee, penalty fees for each year, the company name can be restored to the register. Where we will find that answer?
Page 102.
And what's the answer?
5 years and $600.
Okay. Everyone got it? Yes?
Yeah.
Okay. All right. Explain the difference between striking off and liquidation. Where we find that answer?
So I guess I'll be between pages 99 and 102.
That's page 103.
Yeah, 103. Yeah, 103.
The top of 103.
What 103 said, what it says.
Company which has been struck off incurs liabilities. A creditor can bring a claim against the company, and the court may appoint an official liquidator
Mhm.
and a dissolved company struck off by dissolution. It remains struck off continuously for dissolution. It remains struck off continuously for a period of 5 years. The company shall be deemed dissolved. The registrar may, if in the best interest of the crown, apply to the court to have the company liquidated and appoint.
No, that's the dissolution of a company struck off. So if a company is struck off, what happens?
It's struck from the register, remains liable.
Right, so if it's strike off, it remains. What happens when it's dissolved?
No, it's no longer viable.
So where we find that piece? Or how we know that?
What was the question, Ms. Dawson?
Explain the difference between striking off and liquidation.
Liquidate, is the solution you consider official?
Right.
It's an official process, but striking off, I
But
guess, just leaves
this
the company
solution is
liable.
both, eh?
So if the difference between striking off is when it's struck off, what happens?
Remains viable.
Liable.
Well, it isn't removed from the register, so it remains liable, right?
It's just struck off the register, right? Unlike with the liquidation, what happens with it?
It's
Nothing.
removed. It's
It
removed.
ceases to exist, right? Once a company is dissolved, it ceases to exist. We'll see that on
Okay.
100, on the first paragraph, right after the definition of liquidation. Okay. Okay, what are the circumstances where an IBC may be wound up by the court?
It's a couple.
Mhm.
So one is when the company has passed a resolution requiring the company to be wound up by the court.
So we
So
will
that's
find that
actually
answer.
page 103.
103.
Okay.
The company is insolvent.
Mhm.
The company does not commence its business within a year of being incorporated.
Mhm.
Or when the court is in the opinion that it have to be, where that is right for the company to be unbound up,
Mhm.
or when a regulator steps in and petitions the court for the company to be wound up.
Okay, because they suspend or revoke their license, eh?
Yeah.
When does the winding up of an IBC by the court commence?
Within 6 months, so something we were saying. Wait.
Sorry, Ms. Dawson, what you said?
This is number 10. When does the winding up of an IBC by the court commence?
Once you file the plan of dissolution with the
Yeah,
register.
within 6 months. Once they put in the application, the court must shall be determined by the court within 6 months of it being made, unless the court is satisfied that special circumstances justify an extension not exceeding 6 months.
Okay, so the court,
That's page 104.
everyone
That's what
get
this
it.
question asking, or this asking?
When does
Like,
the winding up of an IBC by the court commence? It
that
commences
starts right
when?
away, you know?
When a liquidator is appointed?
No, when and you just read it,
I wasn't sure if that was referring to that. Okay, so that's
An
what it's
application
referring.
for winding up shall be determined by the court within 6 months of it being made unless the court is satisfied that the special circumstances justify an extension not exceeding 6 months. You all have it?
Yeah.
What
Yes.
page is that on?
Okay.
104.
104. And what actions may the court take on hearing of a whining a petition?
They could dismiss it. They can make a provisional order, adjourn the hearing conditionally or unconditionally, and make any other order that it thinks fit.
Mhm.
Um,
But it will not refuse, it shall not refuse to make the order on the ground only that the company's assets are being mortgaged or charged to an amount equal to or in excess of those assets, or that the company has no assets. Yes?
Mm-hmm.
Okay. So we know we want to know voluntary liquidation, eh? What are the different types of liquidations?
Voluntary and
voluntary and
involuntary.
involuntary.
Okay. And what is the practicality of liquidation? What is it? Why would I want to, why is it practical for me to liquidate?
Whenever your liabilities exceed your assets,
Mm-hmm.
um,
It could be too when there's no need for the company.
Right, so the purpose has been fulfilled, or what else?
or by court order.
Mm-hmm. The creditor may want to get their money, or we have a LDC, right?
Yeah,
Mhm.
limited duration company.
Okay. Okay, so let's try a little review. Let's look at areas we should be reviewing.
Can you repeat that?
Let's look at the areas we should review for this exam.
We still
Okay.
meeting on Tuesday.
You all still want to meet on Tuesday?
Yes.
Okay.
Yes, ma'am.
But
Well,
still give us the
let
area
me
to
give
start
you all the
studying though.
areas to start, and then we could go over it. Because we'll only have to meet for an hour on Tuesday, because you all will already have this down to a science. Right?
We would have already covered a lot.
Mm-hmm. Okay, let's look at companies in unit 1. You should look over companies, sole proprietorship, partnership and companies, advantages and disadvantages of Solomon's principle, that is pressing the corporate rail and the related cases.
Hold on. Sorry, you're going too fast.
Okay,
You could start over companies,
yes.
sole proprietorship.
So let's look in unit 1 at companies, sole proprietorship, partnership and companies, the advantages and disadvantages of Solomon's principle, pressing the corporate veil and its related cases.
The person, the corporate veil.
The pressing the corporate veil, Solomon's principle, that's the case, right?
Mm-hmm.
And the related cases dealing with pressing the corporate veil. Unit 2, incorporation of an IBC, the types of IBCs, and what is the attraction for incorporation of an IBC.
Can you repeat that one more time?
Okay, unit 2, incorporation of an IBC, the types of IBCs, and the attraction for incorporation of an IBC. Unit 3, the terms for incorporation and provisions of memorandum and articles of association.
Say that one more time.
Unit 3,
Mm-hmm.
terms for incorporation and provisions of the memorandum and articles of association. Unit 4, we should know about the director's duties, liability, and indemnification.
Director's duties, liabilities, and
Indemnification. You should read and understand the case of Regal Hastings Limited versus Gulliver.
read and understand which case?
You all know that we done starting off. Regal
Regal.
Hastings Limited
Mhm.
versus Gulliver.
That in the book.
Oh my. This unit 4. Y'all forget that one?
Not really forget.
You should know the statutory duty of care in Companies Act.
Pardon, say that again.
Statutory duty of care in the Companies Act. You should know the degree of skill and care required of a director.
Skill and care of a director.
Mhm. You should know all aspects of a nominee shareholder relationship and the potential liability.
Can you repeat number 6, statutory duty of care?
Care in
Okay.
Companies Act.
That would be the annual filing and declaration.
What is this?
The statutory duty of care in Companies Act.
The statutory, what all you have to do, what your
As-
duty of care is in a
Okay,
company.
all right. Okay, all right.
Now, unit 5, you should know why record keeping is important and the documents to be maintained legally and for the regulatory agencies.
Documents to maintain.
Legally and for the regulatory agencies.
Ms. Darcy, do you know how much questions we'll have?
I think you all will have about 13.
Okay, so it's 13, all 13 must be answered, or is that you have to pick a certain amount or whatever?
I think
Like
you
some
all
will be
have to,
mandatory and then some you have to
you'll
pick.
have about 4 mandatory questions
Okay.
and you have 6 questions thereafter. They're asking you to use case law and legislation where applicable. So obviously you have a little more, you have a higher standard of care they're looking for you to have some high degree of skill in answering these. You should know the laws as well as the case that is applicable.
So the four mandatory are full essay questions.
I don't think so.
So do we have any full essay questions?
I think so.
So with the 4 mandatory questions, we know what topics are for the 4 questions, so we can focus on that.
No, you just get a review. You have to review these areas that she gave.
Okay, so if you could confirm how much
We
essays
we ain't
have
finished
and-
yet now. We ain't finished yet. Y'all have to
No,
get
no,
all this.
Okay, all right, I'll wait.
Mhm. Okay, on this unit 6, you should understand the stages of money laundering, the offenses under the Proceeds of Crime Act, the predicate crimes under the Proceeds of Crime Act,
Repeat the last part, please.
the predicate crimes under the Proceeds of Crime Act, enhanced due diligence, the role of the MLRO, and customer due diligence. Unit 7, 8, 9, and 10, this the area you all know well, right? Yes? You all get all of these questions right, whatever on 7, 8, 9, and 10, yes?
Any of these is mandatory.
The 4 first ones are mandatory.
No, I was saying, is a mandatory question, any of them coming from 7, 8, 9, I think.
I am not sure. I know that's what they tell me is what it is. It's 13 questions. You have 6 questions to choose in out of the 10, and then you have 4 mandatory.
Okay.
In unit 7, you should know the documents to be maintained at the registered office.
Repeat that, please.
No documents to be maintained at registered office. You should know the documents to be filed at the Registrar General's office. That's unit 7 in a nutshell right there. Unit 8, you should be able to explain ERM and how to manage risk. What is ERM?
Enterprise. That's all I remember.
Risk management.
Uh-huh.
And these the questions that you usually ask for what? Remember, we just was reviewing that.
how to manage risk.
And we ask some questions and then you have the answer in a circle, right?
Yeah. So you're saying we need to know this circle.
Yes. That's the only way you'll be able to explain it and how to manage it.
Okay. You said the question was explain ERM and
How to manage risk. Be able to explain ERM and how to manage risk. Got it?
Mhm.
Be able to explain the importance of corporate governance and the levels of risk management responsibility. Unit 9. Know the role, responsibilities, and duties of a company secretary. Do I have that?
Mhm.
Yep.
Okay. Be able to explain. Be able to explain financial statements minutes and meetings. Everyone has that?
Mhm.
Miss Darcy,
Mhm.
is it possible to move the review to Thursday instead of Tuesday? I know that I've covered a little bit more of basically all of the information.
What more? What you mean more of the information?
I mean, there's a difference between Tuesday and Thursday. We would have
No,
studied.
yeah, but you don't, what I'm saying to you is you want the review to happen in order for you to study. You
Oh,
don't
I
want to
get
be,
you.
yeah, you want to,
Oh, I was gonna study to make sure I get.
no, you want to know which direction to head and you don't want to be studying wide and you don't need to
Oh, I
study
get
the
you.
wide.
Okay.
So you know the financial statements? What we had?
Yeah, I have that.
Balance sheet, we had, what we had?
Income,
Income
cash flow.
statement, remember,
Mhm.
right? Okay.
Statement of return earnings.
We have 4, right?
Yeah.
Yeah.
Yes, okay. Voluntary liquidation of a company in Unit 10. Voluntary liquidation of a company, we in Unit 10 now. Process to strike off a company. And winding up by the court. Now this is easy for you all to just follow because all you have to do is go to your book and put the page next to where you need to do for all your review. Just like you reconciling an account. You just put the page and then you know just where to look for these answers, eh? So that should be your first step to go through the book and find which page all of these answers are related there to. And then it becomes easier like that because you wouldn't be all over the book looking for things when you have it right on a little sheet where you could just refer to and go to the page, eh? So it's just like you reconciling your checkbook to say that on page so-and-so is where I had this and page this. And that's where you begin.
Ms. Dawson, you go over the ones for Unit 10 again. What you say?
Unit 10 is voluntary liquidation of a company.
Uh-huh.
Process to strike off a company.
Uh-huh.
And winding up by the court. So for example, in Unit 10, where we'll find voluntary liquidation.
On page 100, right?
From page, okay, that's page
99.
100 in your book. Or
Wait.
it starts
100 or
with
99.
2 types of voluntary
Oh, no,
liquidation.
Oh, page 99, sorry.
Starts from 2 types of voluntary liquidation. And then you go straight from there into what? Striking off. And then you go to winding up by the court, which is what? That's an involuntary liquidation, eh?
When the court get involved, yeah, involuntary.
That's section 190, right?
Yep.
So you already will have you'll have section unit 10, you're already able to reconcile unit 10, eh? Unit 9, you just did that, so you know where to find the answers for that. We have the role, responsibilities, and duty of the company secretary. We have the 4 financial statements. And we know what minutes and meetings there are, right? How many minutes or meetings we have?
3.
Okay, so you see how easy this becomes? And ERM, we'll find that as well. We have a whole cycle to explain it.
Mr. Dawson,
Hmm?
you can hear me?
Okay, hold on. Say it again.
Yeah, I was saying, I wanted to know, so we going with Tuesday?
Yeah, Tuesday. Hold on 1 second for me though, okay?
Okay.
Okay, sorry, go ahead.
No, I just wanted to ask if we was going with Tuesday.
Yeah, so Tuesday we could do it. 6:30 or 7 is better.
6:30 is fine.
6:30 is fine. Everybody will be home by then because I know it's be a rush getting in during that time.
It don't matter, 6:30, it's up to everybody, however everybody else feels.
Everybody's good for 6:30 or y'all want to do 7?
6:30 is fine.
6:30 is good.
Okay, so 6:30, we'll be there for 6:30, so we should be finished by 7:30, 8 o'clock the latest, eh?
Okay.
So you all have a guide, so you could go from there.
Ms. Dawson, I have a quick question. Well, I have two quick questions.
Mhm.
In chapter 10, like let's say we're reviewing the voluntary liquidation, and this comes as a question. So we have to answer this question by stating the two types of liquidation and going into the process of liquidation of an IBC.
So you,
And
is
then
according to what your question is. So in order for you to show you understand, you would say basically, so they'll say, you know, what type of liquidation it is. So they'll say, well, John and Jane are directors of ABC Company Limited. They are no longer able to pay their debts. They have decided, they want to know what can they do to be rid of all of the, if there's any way for them not to have to proceed with or continue with the company without having to pay their creditors, say something like that. So you would say what? There's a company, they have options available to them, which are blah, 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 but you will only focus on the option that is available, that they need to use, eh? So you just want to show you know the difference. And now you would say, but they need to use this way. So you don't have to go into explaining the other way if you only need one way, but you will give an overview so you show that you know the difference.
Okay.
Okay.
And lastly, where exactly will we be taking the exam?
I think that you're going to the institute, eh?
Yeah, the institute.
Okay.
So you'll be doing the exam there. Let me see if anything else that will help you.
But I don't know if maybe on Tuesday, I don't know if you want to talk to Miss Archer writing the exam, right? Are you assisting or?
No, Ms. Archer writing the exam.
Okay. Even if you only talk to her, you can answer like what for mandatory ones we can focus on mainly, because I know that's the one to carry the most points.
Okay. The mandatory ones usually don't, they have the 10, they have, all of them have 10 points, I think. All of the questions you have to answer. But of course, the mandatory ones are the ones you must answer.
Yeah,
Whereas you could
exactly.
pick out of the 6, you can't pick out of them,
Exactly.
so you have to know the mandatory ones.
So which unit would the mandatory come from?
Oh, I don't know.
That's what I was telling her, that I find out for, if she could find out for us and see if she would tell us, so we'll know on Tuesday, like where to focus on, so we can know what we must know,
Mm-hmm,
and then pick through the other ones.
okay. Okay. I think unit 10 is a pretty important unit though.
Yeah, it is.
You should know that one for sure.
All right. All right.
And I think money laundering is an important unit.
Mhm.
And I think companies, the core of companies is an important unit.
Mhm.
And I think you knowing about directors is important to know. I think you should know about, but I think money laundering is important as a whole, because that's a big part of what is driving the financial and services area. You should know corporate governance for sure, but I mean, I'll see if she'll give us any direction, but I think you should know how the company begins and how it ends. And if she tell you read the case, you should read that case and know it. Okay,
Mhm.
Yes,
okay, so on Tuesday, we'll do our review because you all already have reconciled and have everything down to a science if I ask you a question. Okay,
yes,
okay, you all enjoy the rest of your day and I'll talk to you on Tuesday, God's willing.
Okay.
you too.
Take
All
care,
right.
bye.